Okay, you're set.
Thank you so much, Ms. Jones. So today's April 25th, 2025. Wanted to open the meeting and Ms. Jones, could you do a roll call for to document and let the record know who's present today?
I will. And before I do that, Chair Sweeney, I wanted to introduce my colleague, Luis Lopez. He's been with OPF about a month now, and he's here. He's going to assist with some of the roll calls and closing the meeting. And so I just wanted you to know who the stranger was sitting next to me.
Thank
Going
you, Ms.
forward.
Jones. Appreciate it.
Member Bitzer, are you present?
Yeah.
Member Ely did tell us she was going to be absent. So for the record, I just wanted to call her name. Member Garcia? Member Hunker?
Here.
Chair Sweeney?
Here.
And Vice Chair Trujillo?
Here.
Chair Sweeney, you have a quorum.
Thank you, Ms. Jones. And let's just go through some of these logistical items here. The approval of the April 25th, 2025 agenda. I think, is there any changes? I don't know of any changes. Board, do you have any changes? If not, I'd love to entertain a motion.
Well, just one question. Since we got this last minute statement from the Acequia group, does that fit in with the two agenda items we have on EIB 2515, or I'm guessing it's just folded into that discussion, but I guess that's a question for council, or in terms of do we need to modify the agenda any to account for that last minute request that we got?
And thank you, Member Hunker. Mr. or Eduardo?
Hi, so I'm Eduardo, sorry, NMDOJ. It's not on the agenda. It obviously was filed late yesterday, so it's not really before the board today.
Okay, thank you, Eduardo. And so I would move the approve the meeting agenda for today's meeting.
I'll second that.
Thank you, Member Hunker, for your motion, and Member Bitzer for your second. Ms. Jones or your colleague, would you, is there any further discussion? I don't see any further discussion. Ms. Jones or your colleague, do you want to do a roll call vote?
Yes, this is hearing clerk Lopez. So the roll to approve the agenda, Member Bitzer.
I vote yes.
Okay, Member Ellie. Absent. Member Garcia.
Yes.
Member Hunker.
Yes.
Chair Sweeney.
Yes.
Vice Chair Trujillo.
Yes.
Motion passes.
Thank you, Mr. Lopez. Appreciate that. With that, we have an approved agenda, and our next agenda item is number 3, is the approval of the March 28, 2025 regular meeting minutes. Those were emailed out by Ms. Jones, and just wanting to have our board review them. I reviewed them. I didn't see any other changes, but if there are no other revisions, I'd love to entertain a motion.
I will move, we approve the minutes to the March 28th, 2025 meeting as we have them before us.
I'll second that.
Thank you, Member Hunker, for your motion, Member Bitzer for your second. And if there's no further discussion, Mr. Lopez, would you please do a roll call vote on Member Hunker's motion?
Yes, roll call on Mr. Unger's motion. Member Bitzer,
I vote yes.
Member Garcia,
Yes.
Member Hunker,
Yes.
Chair Sweeney,
Yes.
and Vice Chair Trujillo.
Yes. Yes.
Okay, unanimous yeses, motion passes.
Thank you, Mr. Lopez. And with that, I know I'm not present, so I can't see who's all in the audience, or I can only see on the platform. So at this point, I was wanting to, Vice Chair, may I turn the meeting over to you to handle the rest of the meeting? I'll still be on the platform, but just in case there's any in-person logistical things that might be easier for you to handle than I.
Yes, I can go ahead and take over from here.
Thank
So we're moving on to agenda item number 4, which is public comment. And we do have 2 ladies in the audience, but I apologize, I'm not sure who you are. Would you like to introduce yourself?
Good morning, Vice Chair Trujillo and members of the board. My name is Carrie Olson, and with me here is my colleague Angela Harris, and we're counsel for the Olivas petitioners for EIB 25-15.
Okay, so you're not here for public comment then? Okay, fantastic, thank you. Pam, do we have anybody online for public comment?
Madam Vice Chair, I'd like to clarify the scope of the public comment. Is there any limiting of the scope, or is it, can members of the public comment on anything that they want?
Generally, and I see this Mr. V. Hill up there speaking, generally this portion of the agenda item is for any public comment for any topic, whether it's on the agenda or not.
And then the answer to your question, Vice Chair, I have not been approached by anybody who wanted to make general public comment this morning.
Okay, all right, thank you.
Oh, hang on a second. We're seeing on the platform a
Right.
couple of raised hands. And if you'd like to call on them.
Yes, one moment, please. Okay, I believe, I'm sorry, your name disappeared. Whoever had their hand up, is it Ms. Strickland?
There's several of us with hands up.
Okay.
Just so you're aware, this is Andrea LaCruz Crawford. I'm the attorney for the Acequia del Alto in Los Martinez. I'm here to make a public comment, but I know there are other people that have their hands up.
Pam, would it be easier if they sent you their name? Because once they're turn their camera on, their names disappear on there.
If everyone could keep their camera off until we call your name, and then you could turn it on and unmute and make your comment. And I believe, Ms. Stanlin, you got the hand up first. So why don't we start with you? If you would like to, there you go, and unmute yourself.
Thank you so much for that. My name is Rowan Stanland and I live in Cleveland. I know there's a number of people on the platform that
Ms. Stan,
Hi.
Hi, you muted yourself there.
Okay, I apologize. There's a number of people on the platform that would like to make public comment, and we weren't sure the process to sign up or the order. But I do want to say anyone who does to do public comment, it's a raise hand is a feature on the platform on the bottom right, to click that button. And I do want to make public comment, but I also want to defer to Andrea because she has another appointment immediately after this, if she could go first.
Okay, we'll have Ms. LaCruz Crawford go first. And generally we keep public comment to 2 minutes. So if you could just try to keep that within those bounds, we appreciate it. So Ms. LaCruz Crawford, if you'd like to go ahead and make public comment now, please go ahead.
Okay, thank you. Good morning, members of the board and Madam Chair. Appreciate this opportunity to make public comment today. This comment pertains to the request to stay proceedings that was filed on April 23rd, 2025 in the matter of Rancho Escondido LLC's application for a permit for a crusher. I'm appearing today on behalf of my client, who is the Acequia del Alto in Los Martinez. The application by Rancho Escondido LLC, if granted, would detrimentally impact the Acequia and its members as they conduct Acequia maintenance only feet from the location of the crusher. The Acequia is interested in the outcome of this permitting decision and did participate in the permitting action through a letter to Counsel for the Air Quality Bureau that was dated February 12th, 2025, a copy of which is attached to a motion to intervene that we submitted for filing yesterday, but which was only filed today in the proceeding.
Motion to intervene is not on the agenda today.
This is
It's
public comment, Mr. V. Hill. I can make any public comment I
making an
want.
argument regarding your motion. Objection.
Madam Vice Chair, I would second that objection. What we have here is an attorney of a party that's seeking to intervene in this matter and is seeking to evade the legal process and argue a motion for intervene through public comment. She hasn't established a personal tie to this proceeding or concern by the public. She is merely advocating on the behalf of her client to be allowed to intervene, which is a legal question in this matter that's not currently before the board.
And I'd like to just respond to that, that we should have been included as an interested party in this proceeding, but we were not. We were not provided with the notices. We submitted a letter, well, I'm just letting you know this because I think the Air Quality Bureau should have been sending us the notices for this. And I'll let you respond to that, Mr. V. Hill, but you have never sent me a single notice in this proceeding. We weren't even aware of the fact that there had been a petition for hearing filed in this matter. And we were the party who actually asked for this decision to be denied back on February 12th, shortly after the application was filed. So we have been completely excluded from this proceeding. It's a violation of our rights.
Ms. Crawford.
And I think that it's really important that this board is aware of that before they make a decision on this day of proceedings. And the reason it was filed yesterday is because we didn't know about it until just a few days ago.
Ms. Crawford, your 2 minutes are up. And I'm sorry, but this agenda item is for public comment. But your 2 minutes are up, so we're going to go ahead and move to the next person.
Well, I do want to note that I'm lodging my objection to the fact that my 2 minutes included half of my time being expended responding to legal arguments that were provided to a public comment that I should have been able to make for 2 minutes.
Dr. Sinclair, would you like to begin your public comment? Dr. Sinclair, you have your hand up. Do you want to make public comment? There you go. 2 minutes starts now.
Dr. Sinclair, you're muted. Dr. Sinclair, we can see that you're muted. I don't think your microphone's working. We see you talking, but we can't hear you.
Dr. Sinclair, while you work that out, we're gonna move on to the next, but we will come back to you. Gabrielle Olivas, would you like to make your public comment?
Good morning. Can you hear me?
We can, and your 2 minutes starts now.
Okay. Good morning. My name is Gabrielle Olivas. I am just here today in support of the permit and Rancho Escondido. I am also a resident of Cleveland, New Mexico, and I support this matter. Thank you very much.
Thank you, Ms. Olivas. You show up on our screen as LJS. Can you please state your name, and if you still want to make a comment, begin now, please.
Good morning. My name is Lisa Stiles, and I am a resident of Cleveland, New Mexico. I am speaking in opposition of NMED reversing their recent decision disqualifying Rancho Escondido for an operational permit. Rancho Escondido LLC continues to demonstrate illegal and unethical business practices. They repeatedly act with blatant disregard for requirements and the laws, policies, and procedures that govern us all. Just 2 days ago, I witnessed one of their company dump trucks leaving their site and driving down the highway full of crushed material, having no visible license plates. Given these kinds of repeated violations, the NMED should absolutely maintain no confidence that the applicant will conduct operations in accordance with their required regulations. I, for one, value our air quality, our water purity, honesty, integrity, and the rule of law, not the reckless destruction of our resources and governmental institutions. This company should not be allowed an operational permit, period. I ask NMED to not overturn their previous decision and that no permit be issued for Rancho Escondido. Thank you for your time.
Thank you for your comment. Norma Phillips, would you like to make your comment now? Go ahead, your 2 minutes starts now. Ms. Phillips, I believe your microphone is not on. You want to try it now? Can you unmute and begin your comment?
All right, it looks like it's unmuted, is it?
There you go. We can hear you. Go ahead, Ms. Phillips. Your 2 minutes starts now.
Okay, my name is Norma Phillips. I live within 1 mile of the crusher business that's already started. I really oppose this crusher business in this beautiful area in which I live. I am very concerned about the impact on groundwater, on air quality, the noise that I hear, and the beauty is being ravaged, but mostly the air and water quality. So I am opposed to the operational permit of this business. And I remember that when I used to drive along 518, it was just a rough area, kind of forested. The fires came, but it still just looked okay. And right now it just looks like a junkyard. And I oppose mostly on the water and air quality. Thank you.
Thank you for your comment. Dr. Sinclair, do you want to try again? We still can't hear you. You are always welcome to put your chat in your comment in the chat or in an email to me, pamela.jones@env.nm.gov. Okay. Who else? Mr. Martinez, Ed Martinez, would you like to make your comment now?
Yes, good morning. Can you hear me okay?
Just fine. Go ahead. Your 2 minutes starts now.
Good morning, members of the board, bureau staff, and those here present. I'm Ed Martinez. Thank you for allowing me to speak. Since Rancho Escondido began digging rock on the site, the Acequia del Alto in Martinez has interacted with personnel from Rancho Escondido, Mora County Planning and Zoning, Mora County Commissioners, Air Quality, and the Air Quality Bureau. Many permits have been submitted, withdrawn, and denied for the crushing operation. No licenses have been issued. Our acequia is in the midst of this operation and have asked that the rules and laws be followed, the procedures be adhered to. We ask the process for licensing this operation to be honest. I understand that Air Quality Bureau is not responsible for water. Our acequia and the aquifer below the quarry are the lifelines of our community. I thank the Air Quality Bureau for the appropriate denial of the permit 10487 and for sending out the inspectors to the site in reference to the permit and analyzing and reviewing the discrepancies that have existed in the permitting processes. As I've always said before to the Board of County Commissioners who refuse to license or stop this operation, that the denial letter from AQB presented to Rancho Escondido speaks for itself and is an honest depletion of what is transpiring. The decision to deny the permit is a correct one, and all the evidence presently available physically as well as documented. Mora Valley residents thanks you for your decisions. With the help of New Mexico Acequia Association, an independent expert has generated 2 hydrology reports that reflect the influence of the quarry on the acequia and the aquifer below the quarry. This source provides drinking water and irrigation water for the community of the Mora Valley. I would like to present the board with a copy of this report. I have them and I can send those to the boards. They are the hydrology reports presented by independent people. And lastly, our acequia falls within a particular dispersion zone as analyzed in the last permit, and no consideration has been made for the contamination of the water from the particulates and dust. No long-term effects on the water and the air quality have been presented to the residents of the Mora Valley. And our attorney has represented us in her statement because we believe that the process that will go on in this meeting today is unjust to the acequia. Thank you for your consideration.
Thank you, Mr. Martinez. Ms. Stanlin, you want to make your comment now? Okay, let's go on to, I think, Paul, you have your name up, your hand up.
Yes, Madam Chair, Madam Vice Chair, and members of the board, thank you very much for your work on this. My wife and I and my brother own the property immediately across from the crusher property. We are downhill from the crusher property. We are also a parciente of the acequia Mr. Martinez has referenced. We continue to stand in opposition. We thank you for your original action to deny it and encourage you to continue it and not reopen the proceedings. Thank you very much, Madam Chair.
Thank you, Paul. We'll move on to Rowan Stanlin.
Hi, can you hear me?
Yes, we got you.
Okay, thank you. My name is Rowan Stanland and I live in Cleveland. On July 19th of 2024, Rancho Escondido was denied a GCP2 permit from NMED because they did not meet the setback required. On February 21st of 2025, Rancho Escondido was denied again an NSR permit application because they lied on the application. They do not have a conditional use permit or a business license from Mora County to operate, but they continue to do so. They do not have a stormwater pollution prevention permit from the EPA to operate a construction site and are currently being investigated by the EPA. The area of operations is adjacent to the acequia, and there is no erosion prevention measures in place to prevent the silt from entering the acequia. The topsoil has been completely removed and the quarry continues to excavate and haul material off-site. The operation continues to affect air quality. Dust is constantly blowing because all the vegetation has been removed from the quarry area of operations. The current zoning ordinance in Mora prohibits quarrying in Western Mora County in order to protect the Upper Canadian and Pecos watersheds. Mora County zoning was written for the express purpose of protecting its resources and residents from industrialization and pollution, and to preserve Mora's agricultural and cultural history. Rancho Escondido lied on their county application and their business license application, stating that the operation is fire restoration so they could get approved for a conditional use permit, knowing that the use was prohibited. Mora County has failed to enforce the zoning ordinance and is now trying to change the ordinance completely. Rancho Escondido has been in operation for over a year without a county permit. Rancho Escondido lied on their NMED application and has multiple compliance reports showing violations at the site. Rancho Escondido lied on their application by saying that construction had not taken place. This is the reason for their denial. The quarry has been operating for over 6 months under a relocation permit from a company in Albuquerque. As everyone in this room knows, we appealed that back in January. Rancho Escondido has lied to the compliance inspector, stating that the equipment on site was there prior to the permit being approved only because of the rental company, that because the equipment was rented. Identical equipment is still on the site 6 months later. The equipment was not rented. Rancho Escondido has continued to lie in words and actions, and now they have an attorney to lie for them. If I may add, I have reached out to Mr. Vigil about these issues. He appears uninterested in including the public in the process. He appears uninterested in the lies that this company continues to tell, now via their attorney, and he has advised me to contact the Enforcement Division with my concerns. I am certain that everyone in this room understands the health effects of silica dust on people's lungs. I am also certain that everyone in this room knows how understaffed NMED is and how backlogged the Compliance and Enforcement Division is. The enforcement supervisor that Mr. Vigil suggested I contact confirmed this as well, stating that it could take up to a year for any enforcement action to take place. Nonetheless, Mr. Vigil appears to want to kick the can down the road and put the responsibility of this reckless and dishonest company onto someone else. We ask that NMED stand by its decision to deny Rancho Escondido permission to pollute our air and our water. We ask that NMED serve to protect the citizens of New Mexico, not corporate interests. Thank you.
Thank you, Rowan. We'll move on to Paula.
Hello, can you hear me?
Yes, we got you.
I want to look at the bigger picture and why there was no measurement of both the air quality, water quality, and even the soil quality before starting anything, so that there could be evidence of the changes. And I see a pattern that's been going on for years in the States where people are getting away with illegal procedures. And if we can stop this at a small local level, that will be a very good thing for our country, because government's getting away with terrible, terrible things and not following the Constitution and all that. So I'd just like to see more verification of the damage that the air, water, soil is how it's being affected, the flood, how flooding could easily happen. I've been house sitting right next door to their quote parking lot, and bigger and bigger and bigger piles of crushed stone, I guess, are being piled on that property, which has been totally cleared, practically totally cleared of all the flora and fauna that used to be there. So in the big picture, in the long run, the health of all of us in this community is affected, period. And the kids are already exposed to toxic everything, food, air, water, and all that. To add to that toxicity, to me, is a huge error and immoral, in my opinion. Thank you.
Thank you, Paula. Next, Catherine Hardy.
Hello, thank you. I did post the comment. I can also state it.
Yes,
But,
we'll make that part of the record also.
okay.
Your comment.
Okay. So would you like me to also say it?
If you would like to, that's fine.
Okay. Yes. And I am actually I'm an attorney, and I'm speaking on behalf of John and Sarika Abeta, and they are the owners of the historic Mora Inn and RV Park. And they would like, as they support business and economic growth in the community, but they are very concerned about businesses skirting the rules that are there to protect everyone. They want to make sure that all community members and businesses are thriving. And at the historic inn, they want to ensure that their guests enjoy a safe, peaceful, and welcoming experience in Mora. The proposed quarry operation, a few doors down from the historic Mora Inn, is a concern. And in the sense that they understand that, with economic growth, with development, there's also aspects in terms of assurances of appropriate dust mitigation, noise control, and truck safety. And it's not clear that any of those aspects are going to be assured. And the concern would be that this would, of course, negatively impact the businesses and, well, the community. Throughout this process, the historic Mora Inn has observed that Rancho Escondido has attempted to appear to not comply with the standard assurances that would need to be applicable to everyone. And that is concerning. The pattern of behavior does raise legitimate concerns about future violations, legal matters, and environmental impact, and how these things will be handled. And in the sense that leaving it to chance, leaving it to damage until it's corrected later in the future is not a viable option. Again, my clients support the legal and community-supported businesses and economic development, as long as it is beneficial to the greater community, and that the goals that they have are that everyone follows a legal and open community-oriented solution without negatively impacting the other businesses and the community. Thank you.
Thank you, Ms. Hardy. Your 2 minutes are up.
Okay, user Art, I saw you with your physical hand up earlier. Did you have something? Okay. Looks like Jordan, I'm gonna unmute you.
Okay, can you hear me?
Yes, we got you.
Your 2 minutes starts.
Thank you. Well, my name is Jordan Minkin. I live approximately a mile from the quarry operation in Cleveland. I would like to voice my opposition to reinstating or my opposition to approving a permit for their operation. As a local casual observer, I've witnessed multiple continuous violations of state law and local law. I've attended many of the hearings, and I've heard repeatedly that Rancho Escondido is not conforming to requirements, legal and otherwise. I don't think they're functioning in good faith. My request is that the denial stay in place and they do not continue operations. Also, I have asthma and moved to this area to escape the city. I know what it's like to be exposed to silica dust. I have been considerably in my work career. So I would really hate to see the residents of Cleveland and surrounding areas be exposed as they will be with this plant operating. Thank you.
Thank you, Jordan. User Elizabeth, would you like to unmute?
Try her again.
Elizabeth?
On mute. There you go.
Okay.
Can you hear me?
Yes, ma'am. You have 2 minutes.
Okay. Yeah, I'm Elizabeth Blackwell. I want to thank Madam Vice Chair and the board for allowing us to comment. I'm a daughter of a family that has lived in Mora County, more specifically Cleveland, New Mexico, for over 100 years. And Cleveland, New Mexico is a small community, historic community. It has a post office with a zip code that was established in August 11 of 1892. And the town was named after President Grover Cleveland. So it is historic. And I have opposed in the past I have been opposed to the allowing industrialization in Cleveland, and I continue to oppose doing that. I appreciate if you would continue to deny that New Mexico Environmental Division continue to deny the permit. Thank you.
Thank you. Fabio Esposito, if you would like to unmute. Fabio.
Yes, I'm Fabiola Mayas dos Esposito, and I grew up in the valley with the old crusher, and I know how much it affected people in terms of respiratory illnesses. So when it comes to air quality control and crushers, I lived the experience in the past, and I am not in favor of a crusher in the valley. I also use the acequias, and we don't need the aquifer tampered with, messed up. And again, I understand that more economically, people are looking for businesses and way to make money, but it needs to be done in such a manner that we're looking at our future generations. My hope is that my children and grandchildren will be able to enjoy the valley. And I know that when it comes to air quality control, it's extremely important. I have children with asthma. To go visit would be an issue. Therefore, I would like to see the crusher permits denied. If they are going to do things, they need to do it in a moral, ethical, and legal manner. That's been the problem. And so therefore, I am opposed to the crusher continuing because it, like I said, I grew up with a crusher and I know the problems it causes with our health and our lungs.
Thank you, Ms. Esposito. Thank you. Next, Art. Try to unmute again. Okay, let's see if we got you now. It's showing green.
Thank you. Yes.
Yes, 2 minutes, sir.
Thank you. Thank you. My name is Art Brown. I am a resident of Cleveland. I stand by the NMED's decision to deny Rancho Escondido's permit in Cleveland. This type of operation is highly detrimental to the air and water quality of the area and greatly impacts in a very negative way the rural lifestyle of the local population. With that, I ask the NMED to continue to deny the permit. Rancho has broken their promises over and over, and this project must be permanently.
Thank you, Art. Kyle and Clarice Blackwell, if you will unmute. Kyle and Clarice Blackwell. Kyle and Clarice, are you there?
Hi there. Sorry about that. I had
Yeah.
some technical difficulties.
No worries. 2 minutes, please. Thank you.
Sure. I just want to say that NMED has made the right call in rejecting the Rancho Escondida permit application, and we urge them to maintain that position. There's no room for negotiation when it comes to the type of industrial operation in our rural community. We must protect our water, our air, and the unique way of life that defines the area. We're deeply concerned about the example it may set if this permit were to be approved. Granting permission after the fact sends the wrong message. It risks rewarding individuals or businesses for operating without proper permissions or adherence to environmental and community standards. This could encourage others to do what they want when they want, with the expectation that they'll be legitimized afterwards. That's not a precedence we can afford to set in our community. Thank you.
Thank you. And with that, Vice Chair, we have no more public comments.
Good job. Thank you for everyone who took the time out of their day to make a public comment. We will go ahead and move on to item number 5. And Chair, would you like to take back over at this point?
Thank you, Vice Chair. I think I'll have you continue on this, but I did want to also note there was some public comments also in the chat that I was able to see. So Chaconeta and issued a public comment and just notifying Mr. Lopez, and then Mr. Sinclair did share a public comment. I know Miss Catherine Hardy did mention that when she spoke verbally that the comment was in the chat as well. So I just wanted to make those notes. But I think it'd be better if you continue coordinating the meeting, Vice Chair.
Okay, thank you. I will go ahead and continue on to item number 5, EIB 2515. And just for clarification, are you speaking on this behalf?
Thank you, Madam Vice Chair and Madam Chair and members of the board. I am happy to present my position, and I anticipate that Mr. V. Hill, who's the co-movement of the motion, would also speak on the joint.
Okay, well, I'm going to go ahead and have Mr. V. Hill go first, if that's all right with you, Mr. V. Hill.
Yeah, Chris, thank you very much, Madam Vice Chair, Madam Chair, members of the board. Chris Vigil, Assistant General Counsel for the New Mexico Environment Department. This case, there was a petition filed, and we filed our answer this week as required under the rules. So the posture of the case is set for ready for the setting of a hearing, but we have a joint motion to stay the proceedings so that the department and El Rancho Escondido can engage in settlement negotiations. We don't know where that's going to go. But you know, the policy of the EIB is to encourage settlement discussions. Hearings are very time consuming. Again, we don't know where we're going to go. It's a joint motion. There were no other parties in the proceeding. I know that there is a motion to intervene that's been issued, but we will oppose that. I don't want to get into argument about that, just to be fair. So this is ripe for a decision for the EIB today, and the department is asking that the EIB grant the motion to stay. I'll say that granting a motion to stay does not mean that the other parties cannot intervene if that's what the EIB decides. It doesn't affect the rights of anyone. All it does is it means that we are going to postpone a hearing until the settlement discussions bear some kind of fruit. And it could very well be that settlement negotiations fall apart. If they don't fall apart, under the rules, the EIB is required to approve any settlement. So no settlement will be done outside of a public hearing or at least a public meeting in which the EIB votes on it, and in which case the members of the public can come and give comment today. If the EIB sees fit to allow intervention, then of course perhaps argument could be made. So I'll close by saying the department's asking that the EIB grant the motion to stay this matter and to vacate the deadlines for a hearing, and that nobody's rights will be affected at this point. Thank you very much.
Thank you, Mr. Vigil. Just one moment, please.
Madam Vice Chair, if I may be heard on the joint motion before you all render a decision on that.
Okay, well, we're going to go ahead and move on to Ms. Olson and Ms. Harris. So,
Thank you. I appreciate briefly being able to just provide a few other points on this that I think may clarify some of the chaos and confusion for this matter. So the board has regulations that set forth a very specific process for an appeal of a New Mexico Environment Department decision regarding a permit. Here, the decision rendered by the Environment Department was denial of the permit application. If you look to the board's rules, they define party and they define interested persons. Parties are the Environment Department and the applicant. And then the interested parties are other folks who may be interested, who do have and are provided a process under the board's rules for making their positions heard by the board, for cross-examining during hearings, etc. We're not there yet. At this point, following the board's procedures, Rancho Escondido filed a request for a hearing to the board on the Environment Department's decision. And today we were, as council pointed out, going to come before you asking to set that hearing. In the interim, consistent with the board's regulations, the New Mexico Environment Department and El Rancho Escondido have begun discussions on whether we can settle this proceeding. Settlement is expressly provided for, again, under the board's regulations. And in fact, when you look at the very initial steps in this process, after the petition is filed, the board is, if the petition is granted, the board is required to schedule the hearing within 60 days. However, the parties can waive, or excuse me, the petitioner, us, can waive that deadline to allow opportunity for petitioners and the New Mexico Environment Department to determine whether we can reach resolution of this matter before scheduling the hearing. That's where we are today. You've heard a lot of comments and concerns, making factual allegations, and also questions regarding the board's scope of authority in this proceeding, right? And other legal issues that may be outside the scope of that proceeding. There's an opportunity during the hearing process for the board to hear all of those facts and allegations from both sides and render a decision. Again, we're not there yet. Right now, all we're asking is for the board to stay the next steps and allow the New Mexico Environment Department and petitioners to discuss settlement, which the board's regulations expressly encourage, and then come back after that period of time to the board to present and discuss the next steps. So I think, and counsel for the Environment Department can weigh in on this. I think the board could proceed to granting the request for hearing and then stay the proceeding if necessary. Rancho Escondido is in agreement to waive the 60-day hearing requirement, or the board can just simply stay the matter today. Again, we're willing to waive the 60-day hearing requirement and allow us to proceed with settlement negotiations and then pick up with the normal process, including hearing requests for interested persons to intervene in this matter pursuant to the board's rules.
All right, thank you. I will turn to our board counsel and just ask what our responsibility is here. You want to give some guidance on that?
Yes, Madam Vice Chair. So before the board today is item 5 to whether to grant the motion, the joint motion to stay. As you've heard, the board rules encourage parties to settle matters without a hearing. And I think both parties have indicated that they want to take advantage of that opportunity to discuss. So the board does have the option to grant that joint motion to stay. And as a practical matter, that necessarily makes item 6 moot, because there's nothing to schedule if you've granted to stay.
Thank you.
So, of course, alternatively, you could decide to not grant to stay, and then your next step would be to go to item 6, and then you would schedule it before 60 days, and I think that's sometime in the middle of May, and schedule the hearing, which was the original item 6.
Thank you very much for that. So with that information, I'll go ahead and turn it over to our board members for discussion. I believe Member Garcia had.
Thank you, Vice Chair. And just for my own edification about the steps in this process, thank you for your explanation. I understand the stay is before us first, or the request for stay is before us first. And either board counsel or Mr. V. Hill could answer this next question, which is, I understand the permit was denied. That was the agency action already in place. So if we grant a stay of proceeding onto the hearing of the permit denial, then if the parties come to some kind of agreement about the whether the permit is continuing to be denied or not, wouldn't the petitioner Escondido have to submit a new application for a permit because the permit application's already been denied? Wouldn't Rancho Escondido have to submit a new application for permit approval? And then if the department grants that, then there would be another opportunity for the community members who are opposed to the permit. Wouldn't they have another opportunity to request, petition the board for hearing of the, within the right time frame, of course, to petition the board for a hearing of the permit, the new permit approval? So correct me if I'm wrong about these steps.
Madam Chair, members of the board, you are not wrong, Member Garcia. It seems to me that we're going to have a hearing on this matter one way or the other. There will be some, hypothetically, if the board today or at some point in the near future denies the motion to stay, then we'll have a hearing on the denial. If for some reason we engage in settlement and there is a settlement that's proposed to the EIB and under 21-2502, the EIB will have to approve any settlement, and that would almost certainly have to include, I don't know if it would be a new application, but certainly an amended application would at the very least need to be submitted. I don't quite know that a new application would be required. But hypothetically, if the EIB were to approve that settlement, then that would be appealable. Then let's say a new permit would be issued. There's a couple things that could happen here. At risk of giving legal advice to anyone, I want to be sure I'm just describing the process. But if the EIB were to approve a settlement, it would seem to me, just thinking off the top of my head, that there would be a Court of Appeals path to appeal the EIB decision itself, and then there would be a separate EIB appeal on the permit itself that could come back to the EIB. Am I making sense?
Thank you, Mr. Vigil. I guess the main reason for my question is I'm trying to understand what, for the edification of the community members, and I understand if the settlement negotiations fall apart and the denials continues to stay in place, then it's a possibility of going to hearing over that denial. But if there were some kind of a settlement agreement, and as you say, the board would need to approve the settlement agreement, I'm just looking at what clock starts over again, because I understand that if there's, let's say there's an agreement that for some reason there's an agreement that Rancho Escondido has to make some changes to their original application. As you say, it may be an amended application, but it's still a new application in my mind. That would start another clock. I mean, if you approve it because of your settlement agreement, if you approve it, that would start another clock. So that makes sense to me that there would be a new clock, and then the community members could appeal the new permit. Otherwise, you're saying that the community members who are opposed to the permit would need to then go to the Board of Appeals?
Yes, I mean, you're bringing up a good point. Under a permit, there would have to be some kind of public notice and participation on the permit itself. And then if a permit were to be issued, that permit would be appealable directly to the EIB again. is similar to the vacated hearing that we had a few months ago. That's one piece. The other piece is that if a settlement were to be agreed upon, that's a final decision by the EIB, and that order itself could be appealed to the Court of Appeals. So there's a double appellate path that's been opened up to my mind, and maybe Ms. Olson has a different interpretation, but I think that this proceeding has kind of opened up two appellate paths, for better or worse. Complicated procedural situation we're in.
Thank you. Yeah, Madam Chair and Madam Vice Chair, I may be able to just provide a little bit of clarification that hopefully could simplify this for the members of the public, to give them just a concrete something to look at so they really can understand the path forward. And I think the board's rules help on this. I think if you look at subpart 501 and subpart 502, and then the legal citation for that is 20.1.2.501 and 502 of the New Mexico Administrative Code. And the New Mexico Administrative Code is publicly available online. I think they can also reach it through the commission's website. But 502 provides a process for the department to withdraw their permitting actions. So one possibility, depending on how a settlement negotiation could go, is that the department could simply withdraw its decision, and then the rules provide what happens next. And the appeal petition is vacated, the agency must issue a new permitting action within 60 days unless the board approves a different time period or the applicant withdraws its application. The right to file a new appeal petition under the act is available. That appeal petition would again come to the board. Under 502, which is the settlement provision, the board may approve a settlement that modifies the permitting action. So we could modify the NMED action through settlement. We would have to present evidence supporting the modification. Or the next sentence provides the department may withdraw and reissue a modified permitting action under the withdrawal provision. So that wouldn't require the board's action. And to be clear, regardless of what the board decides today, whether they schedule a hearing, whether they grant this stay, the rules provide for parties to enter into, and in fact encourage parties to enter into settlement negotiation. And if that settlement resulted in the NMED withdrawing their permitting action, that is outside the approval process of the board. That's something that can just happen under the rules. If that happens and the board issues another permitting action based on either the existing application or some modified application, we go back to the department's permitting procedures. The interested participants have the opportunity to be involved in that procedure. Here, it's a little bit unique because the decision was made without public hearing, without presentation of evidence regarding the allegations in the denial letter or the technical aspects of the permit, whether the permit as filed complies with the Air Quality Act. We didn't get there in the Environment Department proceeding. If a new proceeding happened in front of the secretary and it went to hearing, that would be a public hearing with opportunity for participation. If instead it happened in front of the EIB, there would be a public hearing proceeding where folks are able to present evidence on that. And then if there's disagreement ultimately with the secretary's decision, the appeal goes to you all. If there's disagreement with the board's decision, there's a right of appeal to the Court of Appeals. And so I think that was what Mr. Vigil is indicating, is there's multiple steps. It's kind of a choose your own adventure, I guess, for how it all lays out. But ultimately, whatever is decided by the board is appealable to the Court of Appeals, to anyone who participated in the proceeding below. I hope that is helpful.
Yes, Ms. Olson, thank you very much. That's very helpful. Thanks.
Member Honker?
Yes, two things. First of all, point of confusion on my part. There was discussion about this 60-day deadline to hold a hearing. When I review the joint motion before us, it refers to a 90-day deadline. So could one of the petitioners clarify what the 60 versus 90-day deadlines are? Because I'm not sure.
To be frank, and Mr. Vigil can comment on this, I think that might be a typo. I think the regulations provide 60 days. Is that right, Mr. Vigil?
I think it's Member Honker, Madam Chair, members of the board. I think it's 60 days to set the hearing, 90 days to have the hearing. So I apologize if I misspoke. I think I caused the confusion earlier. And I'll just say here, I'd like to speak again about some of the issues raised by Ms. Olson. No rush, but I would like an opportunity to respond.
Okay, well, my second question, if we decide as a board to grant this stay in the proceedings so that settlement negotiations can occur, it seems like it would be wise for us to put a limit on that and not just have it open-ended. It seems like we should have some time period, and if there's no settlement, then we'll go back to the other agenda item and consider scheduling a hearing on the appeal of the denial. So my question to the two attorneys is, what is a reasonable time frame? Should we take that course of action?
The department doesn't have any objection to putting a time frame on there. We would just ask that it would be no less than 60 days so that we have sufficient time and possibly come back before the board at another meeting and give reports. The department doesn't object to that.
And Member Honker and other members of the board, we don't object to that either. I think just for transparency to anyone who's watching this, I think it might be prudent to set a deadline by which parties submit a status report to the board. Perhaps 60 days makes sense. And just to report on the board that either settlement negotiations have been successful and we have a proposal to present within X number of days. Settlement negotiations have been unsuccessful, and we request the board put this on the next agenda to set the hearing and move forward with the process. Or alternatively, if something unexpected comes up and we need an additional 30 days to provide a pathway for us to be able to request that from the board and potentially extend the procedure for 30 days. I think the difficulty, as you all I'm sure are very well aware, is that because we don't have a hearing officer assigned for this, the board action potentially requires action taken during your meetings. So we would maybe set the deadlines so that we could notify you with enough lead time before your next meeting so that it could be properly put on your agenda if further board action is required.
Madam Chair, Member Honker, members of the board, the department has no objection to Ms. Olson's proposal. However, the department would ask that Ms. Olson maybe draft a proposed order, and I can help. I'm not trying to put work on anyone, but basically that the parties if this is something acceptable to the board, that the parties can draft a joint proposed or stipulated proposed order for the consideration of the board. And it's something anyway, so yeah. Okay, I've said enough.
Okay, thanks.
Member Bitzer?
A direct question to council. I heard during public testimony the accusation that attorneys might be lying. Is that something that is enforceable or has consequences with the state bar, perhaps, if someone was to actually be? And I understand we don't need to swear attorneys in. You're already sort of like you're officers of the court. You're already sworn in. But part two-parter here. One, am I correct that there would be consequences if someone were actually lying? Let's go ahead and just ask that question.
I think so.
And then number two, I know you often don't, y'all don't typically offer input when you're not specifically asked. So I've had from experience the hard way. I had a hearing that went till 1 a.m. Because we didn't ask the Assistant Attorney General to offer her perspective, and so she didn't. And then she clarified things. But has there been anything presented by department or Rancho Escondido Council that you would take issue with?
No.
That's all I got.
Chair Sweeney, did you have anything?
No, I don't have anything at this point.
Okay, I have just a couple of questions. And we'll go back to Mr. Vigil there. At this time, is Rancho Escondido operating? Are they conducting any operations? And is it, are they allowed to be operating on any level?
Madam Vice Chair, Madam Chair, and members of the board, I can represent to you what I understand from my clients. Your question is a little bit vague because I've been engaged to help them with specifically air permitting for the crusher facility. So when you use the term operation, there's a number of things, as we've heard from the members of the public, that could potentially be happening on that property that are outside the scope of that narrow issue over which you all have jurisdiction, right? And I think we heard things about mining, we heard things about driving trucks, we heard things about a number of other things that aren't related to the request for a permit for a crusher operation. But with respect to the permit, with respect to the crusher operation, my understanding is that there's equipment on site, that there's a legal debate over whether that constitutes construction and whether there was any past operation. That's all in the realm of potential enforcement action before the NMED. My understanding is they're not currently operating a crusher facility.
Okay, and with the thanks of Member Bitzer's question there, I'm gonna ask it just a different way, and I'm gonna ask the same question of Mr. Vigil. As you, assuming we grant a stay and you enter into negotiations, is there any are there any actions being taken that would perhaps either violate or impede the negotiation process because they, on the part of Rancho Escondido, that they would not be allowed to do with the permit that you are negotiating?
I'm not sure I fully understand your question, but let me take a shot at it. And if I miss, forgive me. So I think this is confusing because there's potential for an enforcement action for violations to be brought by the New Mexico Environment Department. They have not brought an enforcement action yet. So that's a separate piece than a petition for a new permit. And then, you know, there's complication, there's jurisdictional issues, there's a whole number of things that we're hoping to discuss and see if we can figure out or at least untangle it with the Environment Department. And so with respect to staying the proceeding for potentially 60 days instead of setting a hearing today that has to occur within 60 days, if you all grant our request to waive that 60-day deadline and set a hearing at a later date to allow us time to figure that out, I don't think it poses any major problems for Rancho Escondido. They would not be operating their crusher facility during that time because they do not have a permit that would allow them to do so. So instead of potentially having a permit within 60 days, if we move forward to hearing today, it would delay their ability to obtain a permit until settlement is completed in whichever of the various pathways we move forward on potentially obtaining a permit at that. Is that?
Yeah. Okay. Thank you. Mr. Vigil, is the NMED, are you working at all with the enforcement portion of the NMED to ensure that as you enter into the next phase of this this issue, into negotiations, that the applicant is abiding by the rules that are generally set forth for somebody applying for an air permit or is in the process of having one denied and reapplying?
Madam Chair, Madam Vice Chair, members of the board. The department stands by the denial letter, and we filed an answer essentially refuting the assertions in Rancho Escondido's petition. So I want to make it very clear that the department is not here saying that there was a mistake in issuing the denial letter. And I will get to your, I'll get to your question, but I just want to make it really clear, because it's not that, you know, there's some sort of funny business going on here, but there may be some room for a settlement, which is a different thing. Right now, and we've had questions of jurisdiction and different types of activities going on, and it's true that the department and the EIB has limited jurisdiction. To the extent that any permit over which the department has jurisdiction and over which the EIB has jurisdiction, they are not allowed to operate. Because they do not have a permit. They do not have an air quality construction permit. And so any operation with regard to that permit would be a violation. I want to be really careful that I'm not making allegations or arguing our case, you know, because we're not really at that point yet. But what I will say in answer to your question, Madam Vice Chair, is that this settlement, to the extent that one may be achieved, is going to be based on confirmed 100% compliance with every single air quality regulation and statute. And there has been a question about whether or not what was done was on purpose and maybe there was a mistake. To the extent that that may or may not be true, that is what opened the door to a settlement agreement. and that, you know, the department was concerned that we treat all permittees fairly. And there was a concern that we're not conceding anything, but there was a concern internally that maybe we were not entirely fair to Rancho Escondido. That's not a decision that we've made. We haven't come to that decision, but I want to be clear, that's the reason why this settlement negotiation was opened. It was not opened because we made a mistake. It was not open because Rancho Escondido has complied with everything. One last thing I'll want to say is that it's very unlikely that we would withdraw our denial letter, because this is a real settlement that's going to have to be 100% based on Rancho Escondido's compliance. And if Rancho Escondido decides they don't want to comply, we're going to go to hearing and we're going to make sure that they don't get a permit. So I want to be really, really clear about what we're doing here and why we're here. I'm not sure if that answers your question. I'm happy to answer any other ones you have, but just, you know, for members of the public and for the board themselves, you know, that's the reason why we're here. That's the reason why we decided to file a joint motion to stay, to see if there was room to bring them into compliance and perhaps make sure that the department was acting in an equitable manner. Thank you.
And Madam Vice Chair, if I could just add one more point of clarity that might give the public some comfort. You're hearing council talk a lot about compliance. That is a dispute. It's laid out in the petition, whether it's appropriate to address non-compliance and violations of the AIR Act in a permitting proceeding, or whether it should follow the statutory procedure for bringing an enforcement action against somebody who is not complying with the law or terms of a environment department issued permit. But I do want to say that irrespective of what happens tomorrow going forward, if the New Mexico Environment Department finds a violation of the AIR Act or the department's regulations, they can bring an enforcement action, and under the statute, that action can incur, sorry, I'm not saying this very well. They can bring an enforcement action requiring compliance and up to $15,000 a day in penalties. And so that's very much available to the department. If we stay this permitting proceeding, all this proceeding is about is whether or not Escondido should be issued a permit. This isn't whether or not Escondido is responsible for past or some unknown future non-compliance. The department has a pathway at any time to bring an enforcement action against Rancho Escondido and assess penalties for non-compliance with the law. So I want to make sure that it's clear that the permitting action, whether or not they should be able to have a permit to operate a crusher facility, does not foreclose or prohibit the department from separately looking into non-compliance at any time.
Yes, thank you both for your answers. Anybody else have follow-up? No? Maybe have a motion? Member Garcia.
Thank you, Madam Vice Chair. And at this time, I would move that the board grant the joint motion to delay the hearing and stay the proceeding.
Purpose of discussion, I'll second that.
Can we get a roll call vote on that? Oh, well, actually, before we go to the vote. Oh, I'm sorry. Member Honker?
Yeah, I would propose we amend that to specify some sort of a time frame. 60 days was discussed by the parties that jointly proposed this resolution. So I would say, you know, we have a June 27th meeting. So it seems like we should request a status report on this in advance of our June 27th meeting so that we could put it on the agenda for that meeting and reconsider whether, has the settlement been successful? Is it still ongoing? Do we need to maintain this suspension for an additional period? Or do we need to go back to the petition objecting to the denial? So, it seems like we need a milepost out there that we're going to revisit this and decide what needs to be done going further from there. So,
Thank you, Member Honker. I completely forgot about your suggestion about creating a deadline. So I would amend my motion
One more thing.
Oh,
I apologize, but I think Mr. Behill brought up a good point about hearing officer being appointed to this. And we had previously had Ms. Orth as the hearing officer. I think she's still available. And maybe we should consider going ahead and assigning a hearing officer as we move through this, the proceedings. And I'll defer to counsel here if that is possible. Can we do that?
Madam Chair, yes, I think you can.
I believe we can assign one now, right, as part of the procedural aspect of it, and we would need to make it in our motion as well.
That's right.
thank you. Thank you for that clarification on my motion. Okay.
one more question. But we're not scheduling a hearing at this point. So the purpose of designating a hearing officer is just to have one in the wings for if and when we go to the hearing phase.
Also, if I may, Member Honker, it would facilitate the procedures as well. So I think there was a challenge this week with the filing of this motion, which had to go to the board, which, as was pointed out earlier, required a public meeting. So if you have a hearing officer, then the parties, as they're working, maybe even delivering a status report or things like that, they can do it via the hearing officer.
That makes some sense because the hearing officer could deal with any procedural issues that came up in the interim. So, okay, I'm good with that.
Now, before we go into the motion, I just want to reach out to Chair Sweeney in case you had any comments or anything. I forgot to look up that direction.
That's okay, Vice Chair. I'm good. No comments.
Thank you.
All righty then. Thank you, Madam Vice Chair. And I would like to amend my motion to the board for approving the joint motion to delay the hearing and stay the proceeding with the requirement that within 60 days or by the next meeting in June 27th to have a status update submitted to the board to let us know how the negotiations are going, if they are continuing to go, and what the status is of those negotiations. And also to have if there is a hearing on the denial of the permit, that there be a hearing officer designated for that, which would be Felicia Orth.
I think we want to just leave it open for a hearing officer in case there's any issue with Felicia's schedule.
Okay, that there be a hearing officer designated with approval of the chair and vice chair.
How does that sound?
If it works. I mean, I understood that Ms. Worth is available.
Mhm. But we usually defer to council, make sure we checked all the boxes there.
Yeah.
Okay, great. Do we have a second on that?
I will second that. Joint second.
Okay. Can we have a vote?
Yep. Okay, vote on Member Garcia's motion. Member Bitzer,
I vote yes.
thank you. Member Garcia,
Yes.
thank you. Member Hunker,
Yes.
thank you. Chair Sunia,
Given some of the work in my professional capacity, I'm gonna abstain.
okay, thank you. Vice Chair Trujillo,
Yes.
okay, motion passes.
I'm sorry, I was just asking if we moved that meeting from the 27th. I thought we had during our last hearing or during our last meeting, we'd moved that meeting. Do you happen, I know Pam had to leave, but do you happen to have the board schedule for the next couple of months? That's okay. We might need to double check that date for the 27th because I believe we made some dates, moved some dates there.
Vice Chair, this is. I think it was in relation to setting some hearings when potential hearing officers were or were not available that last week.
Okay. And so this will probably be a question for Eduardo, our counsel, but since Chair Sweeney abstained from this particular issue, and I will not be at the 27th hearing, or I won't be able to make that meeting. Do we have a method to appoint somebody else? Will we be okay?
You're talking about the meeting in June?
Yes, June.
Yes.
Yeah. Okay, great. Okay. Well, I guess that makes item number 6 moot. So I can turn it back over to Chair Sweeney.
Thank you, Madam Vice Chair. So that takes us to agenda item number 7, our next meeting and upcoming matters. And I know Pam left the meeting, but I believe we still have our meeting in May scheduled. Is there any, and again, we'll just wait to see if there's any agenda items for that meeting. And we'll keep the board updated as to if Pam or NMED receives any, our administrative support receives any requests for agenda items during that May meeting. Is there any other questions by the board if on upcoming meetings or matters or constraints on schedule?
Oh,
Yes.
Misha?
Madam Chair, we start a
Yes.
hearing Monday. This is Felicia Orth. We start a meeting Monday, a hearing, excuse me, 9 a.m. Monday morning on regional haze.
Thank you, Ms. Orth. And just making sure with the board, can you restate when that meeting starts again?
9 a.m. Monday morning. We have allocated 3 days. The Environment Department is the petitioner. They have 5 witnesses and 3 rebuttal witnesses. El Paso Natural Gas has 4 direct witnesses and 4 rebuttal witnesses. Enterprise Field Services has 2 direct witnesses and 2 rebuttal witnesses, and Targa has 1 direct witness. Namoga is in the matter, and Mr. Maxwell is in the matter, not presenting witnesses but opposing the petition. You have all of the direct and rebuttal testimony in hand, and so you'll be able to see all of that before we begin Monday morning.
Thank you, Ms. Orth. Any members of the board have any questions? That is upcoming starting April 28th for 3 days, as Ms. Orth indicated.
I was just going to say, thank you, Ms. Orth, for reminding us of our homework over the weekend. So.
Thank you so much. Other than that, is there any other questions?
Member Bitzer has his hand up.
Oh, yes, Member Bitzer.
Will I be able to attend this one online Monday? I can be up here Tuesday and Wednesday, but Monday I'm in the meeting equivalent of an Iron Maiden down in Albuquerque. So I won't be, I can attend, I just have to be physically present. But if online is going to work on Monday?
Yes, we'll have the same WebEx style of meeting for Monday, Tuesday, and Wednesday.
Thank you.
Madam Chair, one last thing, if I may. I think it's implicit in our discussion earlier today, but for the party that filed yesterday, the motion to intervene, I think the board has taken and will take that under advisement. And just, we didn't say that earlier, but I think it's important that they're aware that the board is going to do that. And that was it.
Thank you so much, legal counsel. Appreciate that comment. All right. Let's see. There's no other discussions. I know we'll be seeing everybody on Monday again. And our next item is number 8, adjournment.
I move we adjourn.
Second.
Thank you, Member Bitzer and Member Hunker for your second. Mr. Lopez, would you please do a roll call vote on adjournment?
Yes, Madam Chair. Vote on adjournment. Member Bitzer.
I vote yes.
Member Garcia.
Yes.
Member Hunker.
Yes.
Chair Sudian.
Yes.
And Vice Chair Trujillo.
Yes.
Okay, we are in adjournment.
Thank you so much, Mr. Lopez, and everyone have a wonderful weekend. And board members, I know we got some homework to do before Monday, but great to see everybody, and stay healthy out there, and we'll see you Monday.